My name is David Hollow. I'm an attorney with the law firm of Hollow and Hollow, and I'm here to do an interview for the Knoxville Bar Association Legal History Project of my law partner and father, Richard L. Hollow. Can you please state what your full name?
I'm Richard L. Hollow.
And what's the L stand for?
Lampton.
All right.
An old family name.
Okay. When were you born?
July the 8th, 1940, in St. Louis, Missouri.
Okay. And did you spend all of your life in St. Louis?
No, I was only born in St. Louis. I was a high-risk pregnancy, so I was born in St. Louis. My folks lived at that time in Cuba, Missouri.
Where's Cuba?
About 90 to 100 miles west of St. Louis on Highway 66.
Okay.
Old Route 66.
Was it a small town?
Very small town.
What was the population?
About 5,000 people.
Okay. Probably still that way.
More than likely.
Okay. And
The big industry was a stave mill.
okay. Did you grow up in Cuba?
Lived for the first 4 years in Cuba, and then my folks moved to nearby Rolla, which is the home of the Missouri School of Mines and Metallurgy. And we lived there until we moved to Tennessee.
All right. And did you come from a legal background?
No.
What did your father do?
My father was actually in the funeral business prior to coming to Tennessee.
And did your mother work when you were living in Missouri?
No. Mother was trained as a school teacher, but she did not work as a school teacher until we got to Knoxville.
Okay, so you had no family legacy, at least that you knew of the practice of law.
Well, my mother mentioned some of her family, distant family members that had been lawyers. One, in fact, a gentleman named Ruby Hewlin had been a federal district judge in St. Louis.
And I believe that the Hollow family actually were skilled tradesmen. Was their general
They were
profession?
in the background. Yeah, they were tradespeople. Came from, I believe, the region of Cornwall in England, and that is the Hollows, and the Fannings was the other side of that of my father's family, and they were Irish and worked on the railroad, the Frisco Railroad.
Now, is there some connection with a church? Was it in Virginia that was built by a relative of Bruton Parish Church, perhaps?
My mother can trace her family back to the founders of Bruton Parish Church, yes.
Okay. Well, so tell us a little bit about your educational history.
Well, I went grades K through 8 at St. Patrick's School in Rolla, Missouri. It was a parochial school taught by the Sisters of St. Joseph. There were 8 members of my 8th grade class. The school was small. We had 3 grades in the same classroom. Actually, the school was an old home which had been purchased by the parish and converted to a school, and Highway 66 ran right through the center of it. On one side, the north side of Highway 66, there was the old home place which housed the convent for the Sisters of St. Joseph, the 3 of them who were there, and also they had grades K through 2. Then you crossed Highway 66, and behind the church was an old accessory building which had been converted into a classroom, and it had grades 3 through 5. And then you came back across Highway 66 to a converted 3-car garage, and that was grades 6 through 8.
Yeah, but, at some point, I think that the family moved to Tennessee.
Family moved to Knoxville in 1954.
And how old were you in 1954?
14.
Okay. So when you moved to Knoxville, you were ready, I guess, to move on to high school.
Came to Knoxville in the summer of 1954, and I entered Knoxville Catholic High School in the fall of 1954.
And I take it you graduated in 1958?
1958, yes.
Well, now there was something significant, I believe, about your time at Knoxville Catholic as it pertains to your career as an attorney. And why don't you tell us about that?
Oh, yeah, that was a good story. I've enjoyed it a lot in my memory, my recollections. Somewhere, somebody on the faculty decided that we should have a mock court or moot court. And it was to be conducted all by students. The attorneys were to be students, witnesses students, and the jurors were to be students. The late William Fitzgerald, Bill Fitzgerald, was the mentor for the defense group, and an attorney named, let's see, I can't remember his name, but he was an attorney with TVA, and he was to mentor the plaintiffs group. And Franklin Kindig, a classmate of mine, and myself were selected to be the attorneys for the defense. And what they had done, they had gone to a Knoxville Circuit Court jury trial, and they had taken the summary of the witnesses' testimony and the pleadings, and they gave it to all of us, and we actually prepared and tried the case. We picked the jury, we presented the witnesses, made the arguments, and the jury decided the case. It was presided over by then Circuit Judge Kelly. I believe his first name was John Kelly, and he was a circuit judge here. So he actually presided over the case, and we tried it. Franklin and I were, as defendants, we had kind of a tough case, and we wanted to see how you could reconstruct an accident. And as we walked out of the front door of Catholic High School after one evening, it was getting dusk, and looked across the street, Magnolia Avenue, because Catholic High School at that time was on Magnolia Avenue. And we looked across Magnolia Avenue to an intersection where an intersecting street on the north side of Magnolia made a T intersection into the Magnolia. And there was a police cruiser parked there. And it was summertime, and the window was, or spring, and the window was down. So we decided, let's go talk to that officer and see if the officer can tell us something about reconstructing an auto accident case. So we walked across the street and walked up to the police cruiser, and the officer inside was a sergeant. His name was Ben Sarton. And we told him who we were, what we were doing, and was there anything that he could give us that would help us or put us in line to find out something about accident reconstruction. He had just come back from Northwestern and had a little traffic reconstruction booklet, which he lent us and gave us some information about reconstruction in general and wished us well. And we promised him we'd get the book back to him. Well, Ben and I became acquainted then, and later when I was deputy law director for the city, he was a captain in the police department, and we continued to have a professional relationship at that time, and he and I stayed in contact with each other until he passed away a few years ago. He always liked to get into a discussion with people at gatherings and point out that he was probably the reason that I was a lawyer. And so but anyway, we tried the case. Franklin Kindig later went on to become the editor of Omni magazine. And we tried the case, and the jury found things our way. And afterwards, Judge Kelly mentioned to me that he thought I might have the aptitude to be a lawyer. So I guess that planted the seed.
Did it stick, or was there some other profession you were still considering?
That was an interesting tale in and of itself to me. The folks at Catholic High School decided that they would give us an aptitude test during our senior year, and that would help us guide our future. And the three areas, they scored you in your top three areas of, I guess, of interest or ability or whatever. And my top three were writing, journalism, persuasiveness, law, and teaching. So in that order. So bearing in mind that I'd been told by professionals what I should do with myself, I decided that when I went to UT, I entered the School of Journalism in the College of Business Administration.
And when did you do that?
Right after graduation.
So you were still in 1958?
Would have been yes, that's right. Would have been the fall of 1958.
Now the path to a law degree was different in those days, wasn't it?
It could, yes, certainly was. I think it's been alluded to by other people who have done these segments. We had a program where you could do 3 years of undergraduate and then 3 years of law school, the 3 and 3 program. And your final year of undergraduate school was your first year of law school.
Is that the path that you chose?
Yes, yes. Yeah, that was the thing that I did. When I was a freshman, my father had his first of 5 heart attacks. And then when I was a sophomore, my mother, who at that time was teaching school, suffered a stroke. And they both went back to work afterwards. But I had to work. And so cutting the time in school was very important to me.
And is that the reason that you decided to start working on a law degree?
Actually, my mother was the one that put me on that path. I was on my way to journalism, and she mentioned that she thought it would be a good idea for me to see what it would take to get into law school.
For the historical record, what was my grandmother's name?
Mildred.
And your father's name?
James.
And was my grandmother working at that time at Bearden High School?
She was.
And she went on to work. She did a full career and retired from Bearden High School. Taught history, I believe.
Taught history and I think social studies or whatever at Bearden High School, yes, until she retired.
Okay. And while you were in law school, or sometime prior to it, I believe you went to an event that became quite significant in your life, where you met a person.
That was after law school.
Okay.
Yeah. Well, after law school, I became the law clerk for Chief Justice Hamilton Burnett of the Tennessee Supreme Court.
Let's back up a minute. When did you graduate from law school?
1964.
And did you sit for the bar the same year?
I did.
Okay.
I was admitted to practice in August of 1964. And the state had inaugurated a law clerk program for the Supreme Court justices in 1963. And the very first law clerk for Justice Burnett, who was from East Tennessee and had his office here in Knoxville, was Charles Susano, who is now on the Court of Appeals and has been for many years. So Charlie was the first law clerk for Chief Justice, and it was a one-year appointment. That was it. I mean, there were no reappointments at that time. You served a year, and then you had to find something else to do. So Charlie went into practice. I was asked if I'd like to do the job, and I took it. So I became his second law clerk. And during that period of time, he would designate me to go to events in his place if he didn't want to go or he was busy. So there was a reception for incoming law students at the University Center. And I went at his request. And a very attractive blonde-headed young woman wearing a green velvet dress came in with an older-looking man, turned out to be her brother. And I thought that was a pretty neat person. So I walked up and horned in on the conversation, and we got acquainted. We've now been married 50 years.
And that's of course my mother.
That's your mother and my wife Judy.
Judy, okay. And what was her name? Her maiden name?
Bass.
Okay. So you're a law clerk at this time. What happened next in your career? Where'd you go next?
Well, we were engaged to be married, and I needed to look beyond my one-year clerkship. And it didn't pay a lot of money. It paid $400 a month. And 10 cents a mile for mileage, but I never drove because the Chief Justice didn't like to fly. The trains weren't reliable, so we drove his Cadillac, and I was his chauffeur. And so I didn't collect any mileage. I just drove his Cadillac to Nashville and to Jackson when the Supreme Court would meet over there. But they did pay me $7.50 a night for hotel accommodations, and I believe it was $10 a day for meals.
What were your duties when you were working for the Chief Justice?
In those days, the way they worked, they would hear oral arguments, and then they would meet and divide up the cases. And when we got back to Knoxville, or if we were here, we would take the cases and work up the opinions. And what Chief Justice Burnett would do would be hand me a case and ask me to prepare the opinion and a proposed opinion, and I would, and he would then review it, and then if he liked it, he would send it around to the other 4 justices, and they either agreed or disagreed, and it got signed and became the rule of the case.
Any of those opinions that you remember were maybe particularly significant?
I don't know that any of them were very significant. I remember one lawyer talking about a case that I had that I think the name was Barr versus Charlie. It was a contributory negligence case. He was kind of scolding me because my opinion made them work pretty hard to work their way around it in defending a case.
So how long did you work for the Chief Justice?
The year.
Just a year.
Mm-hmm.
And then where'd you work after that?
Well, after that, the city of Knoxville decided to inaugurate a program to have a deputy law director because it was getting to be too much for just the law director and his part-time staff attorneys. At that time, Bob Crosley was the law director. He had just finished a 30-day stint as interim mayor, and Leonard Rogers had been elected to fulfill the unexpired term of John Duncan, who had successfully sought election to Howard Baker Sr.'s seat in Congress following Howard Baker Sr.'s death. And so they decided that they would have a deputy law director, and it paid a lot more money, and so I applied for it, and I was selected.
And how long were you in that position?
A couple of years. Went into that and did that job, and then, during that period of time, it was interesting to me anyway. My duties included trying the cases for the city in city court, handling the city court appeals, which at that time went to circuit court, going to city council meetings and writing ordinances, and being the legal counsel for the Metropolitan Planning Commission. And then when I wasn't doing anything else, taking care of the office duties. In those days, Knoxville City Court had general sessions criminal jurisdiction. So for all criminal offenses occurring within the corporate limits, it was city court, just as it would be in sessions today. So you did preliminary hearings in murder cases, armed robbery cases, whatever there happened to be, major felonies, whatever. And that was before the Supreme Court of the United States had declared that it was double jeopardy to be tried on a city ordinance violation and a state law violation concurrently. So every case that came up where there was a city ordinance violation and a state law violation, you tried both of them at the same time. But you had 2 different burdens of proof. The city ordinance violation was preponderance of the evidence because it is considered a civil case, and the criminal case would be, of course, beyond a reasonable doubt if they signed the waiver and allowed you to try the criminal case. The most frequent occurrence of that was in DUI cases, where you'd have a city ordinance and state law violation, and you try the 2 concurrently. City court was a very unique animal, having that kind of odd jurisdiction. And also, the judge at that time, it was named Charles Kelly, and his court had come under a lot of criticism. The Knoxville News-Sentinel, for example, had editorialized strongly against him, and a number of challengers had run against him, and they were all unsuccessful. City Judge holds a term of office, popularly elected, holds a 4-year term of office, not 8, like the state judges are. And so Judge Kelly, the accusations were made that the city court was corrupt. And lawyer Joe Levitt's daddy was the city editor of the News Sentinel at that time, and he led some of the editorial campaign against Judge Kelly. Well, when I was appointed as deputy law director, my job was to go in and take care of city court. And at the same time, Leonard Rogers removed the then city court clerk and appointed dual city court clerks. One was Johnny Bob Yarborough, who was the wife of Knoxville News Sentinel reporter Willard Yarborough, and the other was Mrs. Hugh Simpson. Hugh Simpson was a long time, very well-known lawyer in Knoxville. Her name was Virginia. So Virginia Simpson and Johnny Bob Yarborough were the two clerks, co-clerks. When we got into city court, what we found was that not every case was being tried, or not every case was being pleaded out. We found over 500 cases that had been stuffed in the back of, where the warrants had been stuffed in the back of file drawers and desk drawers, as if they were never to see the light of day. Well, the bonding companies also had an interesting practice of actually practicing law in city court. The judge let them do it. When a case would be called, if a bonding company had the defendant bonded out, they'd say, stand up, and they'd say, Judge, could we have 10 days on that? Could you pass that for a week, pass that for a month? He would always do it. And there were about 4 or 5 bonding companies doing business in the alley behind the old city court building, which was underneath the interstate where the old Beatty Chevrolet company used to be, and it's now part of the rescue mission. It was an old stable, actually, before it became the police department, or the safety building. Had a small jail there. But the first thing we did was forfeit all the bonds on the cases that had not been disposed of. Well, that put all the bonding companies out of business until they paid the forfeitures. Only one could afford to pay the forfeitures. And it did, and it remained in business. The rest of them disappeared. We also put an end to the bondsman practicing law. In other words, if you wanted a continuance, you had to do it either pro se or with counsel. And then the question was, what do you do about Judge Kelly? Because the disposition of cases in his court were interesting. And he wouldn't quit. And he couldn't, and nobody could defeat him. So it was sort of a standoff. And the reason that he didn't want to quit was he didn't have a pension. So city council passed an ordinance granting him a pension. Now remember, his post was created by the city charter, which is co-equal with a private act of the legislature, but they created the pension by ordinance. And after that was done, he retired. And while we were looking for a new judge to appoint, we had a series of interim judges that came in and took over the docket. And those judges were lawyer Fred Musick of the firm of Jenkins & Jenkins and Charles Maynor Sr. Charles Maynor Jr. became law director, and of course everybody with any time and grade in the bar remembers Fred Musick, probably one of the best trial lawyers around in terms of insurance defense cases. And we would start the docket at 9 o'clock in the morning, and we would go until 5 or 5:30 in the afternoon. Take a half an hour for lunch, and that was it. So you had to have a judicial bladder, and you had no time to prepare your cases. As the case came up, the officer came in, you ran through the questions and tried your case. So every case you tried, probably 20 or 25 cases a day, were just cold. And after a while, you get a pretty good feel for the courtroom doing that day in and day out. And then after about a month or two, and the docket got itself pretty well straightened out, City Council appointed a judge, Jess Butler. Jess Butler had been an unsuccessful candidate for city judge prior to that. And so I was at council meeting along with the law director, who at that time was Jonathan Burnett of Franz McConnell and Seymour, later Hodges, Dowdy, and Carson. And after the city council voted to hire Jess, they sent me downstairs to make the phone call to call him and tell him that he'd been selected. That was before cell phones.
When did you leave your position as deputy law director?
The word got out that the University of Tennessee legal clinic, with which I was familiar, since everybody had to go through clinic, at least the civil part of clinic, in order to graduate. Legal Clinic had gotten a grant from the United States to expand the legal clinic program and to inaugurate the actual delivery of the program in the community itself. Because prior to that, the clinic was located in the basement of the law school, and if you wanted to come to the clinic for help, you had to come to the law school. So with this new federal grant, they were going to hire 2 new instructors in the clinic program at UT, and they were also going to open 2 neighborhood law offices that would be staffed by the instructors and also students. So that was the first delivery of neighborhood legal services for the indigent in Knoxville. And I applied for one of those jobs and got hired. And at one time, it was written up in a publication that we had the largest law firm in the city, because every student that was enrolled in the clinic program, as well as us as instructors, were considered part of that law firm. And so we would staff the neighborhood centers 5 days a week, and the students would assist us. And then we also instructed the students in the clinic program as well. Jim Pryor and myself were the 2. Jim was the brother of Bob Pryor. Bob and Jim both were the sons of a real estate agent here in town named C. Laverne Pryor, and her husband, who was one of the principals in the Trailways bus system here.
And how long did you work with the UT Legal Clinic?
Till I went into private practice in 1969.
Now, when you went into private practice, your main area of focus was what?
Whatever walked in the door. Didn't have any really main area of focus. Just like any other young lawyer that hangs out a shingle, you're grateful for whatever you can get that pays. I mean, there's no trick to getting cases. There's no trick to getting clients. The trick is to get clients that pay.
That pay, yeah, absolutely.
And so that was the challenge. I remember when Judy and I were married and walked into the little office that I had and looked, and on the corner of the desk there was a divider, and it had about 9 compartments in it. And we both thought that if I could get enough cases to fill that divider, I'd really be in good shape. Because I had no cases at all at that point.
How long did it take you to fill the divider?
Not very long.
Do you recall, I guess at some point your focus became trial practice?
Oh yeah, it was always trial practice.
And do you recall your very first jury trial?
I don't know if it was my very first jury trial, but it was certainly one of the first. When we were in the clinic program, we were appointed to defend some indigent cases. And one of them was a case, the defendant's name was Harold Leonard White. he was a young African American, about 16 years old, who was being tried for murder in the first degree as an adult. And what had happened, he had fallen in with some bad company. His father was a long-time, very, very trusted and an outstanding employee at Knoxville Utilities Board, KUB. And Harold fell in with some bad company. He had several brothers and sisters. And the 18-year-old that he started running around with was dating his sister. And his sister became pregnant. And Harold had laid out of school one day and was hanging around a neighborhood store. And a gentleman who was retired, who lived in the neighborhood, came into the store, cashed his Social Security check, and bought some Halloween candy and a pack of cigarettes. And the two young men followed him home, and in an alley they committed a strong-arm robbery. And they took the balance of his Social Security check, which was less than $100, and the medical examiner testified at trial that they had pounded his face into the cinder surface of the alley with such force that cinders were embedded a quarter to a half an inch deep in his face. And he was able to, he became unconscious, and then he roused up and made his way home and lapsed into unconsciousness and subsequently died. So the police did not know who it was, and they arrested a young woman for shoplifting. And they suspected that she might know who the perpetrators were, and they told her that she was expecting a child. She was unwed, and they told her that she was going to give birth to the child in jail unless she cooperated with them. So she identified Harold Leonard White as one of the perpetrators of the robbery and killing. At that time, he was in juvenile over in Pikeville. So the police went over to Pikeville and picked him up, and 2 detectives put him in the car and brought him back to Knoxville. And remember, he's 16 years old. And by some coincidence, during that trip from Pikeville to Knoxville, sitting in the back seat of the police car with a police detective, he confessed. He had no lawyer. He hadn't talked to his parents. But of course, he didn't need a lawyer or his parents. He just wanted to confess, which he did. So the first thing we did when we were appointed on the case was to attack the confession. And we went after it as hard as we could possibly go. And the criminal judge at that time was Joe Duncan, by the way, one of the best judges ever to hold a trial court position in Tennessee, in my opinion. Absolutely a great judge. Always maintained control of his court, but you never knew it. He was very unobtrusive. I never heard him raise his voice except one time. And Phil Durand got to him a little bit, and he raised his voice, but that was the only time that ever happened in all the time I practiced in front of him. So we made our motion, and he granted us an evidentiary hearing, and we held the hearing. The hearing lasted 8 hours. And we thought we had a shot at getting the confession tossed. And I remember that when the court ruled that the confession could come in, it was just like taking all the air out of you, because at that point you realized that now you're going to defend this child on this charge, and the confession was going to come in, and it left you with a very defeated feeling, but you knew you just had to do the very best you could. So we tried the case, and in those days, I think as Paul Dunn indicated in his segment, the jury in Tennessee in a criminal case fixed not only the punishment, guilt or innocence, but also the punishment. So the jury found him guilty of the lesser included offense of murder in the second degree, and they sentenced him to 20 years. And he appealed his case, but by that time I was out of the program and in private practice. So the clinic continued to represent him, and the appeals were unsuccessful.
What was the practice of law like in 1969, 1970 in Knoxville?
Well, actually, 69 and 70, we had transitioned into the new rules of civil procedure, so it was similar to what we have now, except not nearly so well developed. It wasn't as complex as it is now. You know, we can take something simple and make something complex out of it, and that's, of course, what I think we've done in many instances with the rules of civil procedure. But prior to that time, see, I came into practice in 1964, we were still in common law pleadings. And those were formalistic, ritualistic type pleadings. If you didn't put the right words in the right order, your case was dismissed no matter what the merits were. I remember one case, the University of Tennessee decided that they were going to do something with a piece of land they owned at the corner of Neyland Drive and Kingston Pike, which is where the Welcome Center is now and used to be the faculty club. And they decided they were going to build some kind of a structure in front of it closer to Kingston Pike. And a group of neighbors objected, hired an attorney. The attorney filed a lawsuit in Chancery Court seeking to enjoin the city's action, the university's action. In those days, you know, when you had a Chancery pleading, if you were asking for an injunction, it was required that you put on the pleading, this is the first application for extraordinary process, or second or third, or whatever it happened to be. That was required. Well, the attorney who was representing the neighborhood group did not put that on the Chancery pleading. And the defense laid back and waited for him. And then when they got into a particularly important phase of the case, they popped it on him, and the case was dismissed because he failed to put that magic language in the pleading.
So how did that change when the rules of procedure were adopted?
Well, when the rules of civil procedure were adopted, you know, the sort of ritual, formalistic kind of pleadings were de-emphasized, and we took more of a look at the substance rather than the form.
Now, I would imagine let's say when you entered private practice in the 1970s, I would imagine the legal community in Knoxville was much smaller than it is now.
Oh my goodness, yes.
Do you have any idea what the demographic was in those days?
Well, we had probably 200 to 300 lawyers in the Knoxville Bar Association.
How did the lawyers get along with each other?
Well, with very few exceptions, it was an extraordinarily collegial group. Very, very, very good group. Defense lawyers would sometimes become very busy and would neglect their cases. And sometimes, I'm sure that never happens now, but in those days, if a plaintiff's lawyer had had a situation where a default could go down, they would pick up the phone sometimes and call the defense lawyer and remind him that they needed to file an answer. I'm not sure that everybody would do that today, and I'm not sure that that was something that wouldn't be criticized if it was known widely at that time, but that's the way it was. And one example, now this happened after the new rules came into effect, but one Friday afternoon, I was asked by another member of my firm if I could try a case Monday morning in Monroe County. I said, "What case is that?" And it was a governmental tort liability case, non-jury. And the attorney who was assigned to it had some real serious problem and could not do it. So I took the file home, read the depositions, but I just assumed that all the pleadings were in order. So I read the depositions and made sure that the witnesses were going to be there. And Monday morning, I was in Madisonville to try the case. When the judge took the bench, he looked over at me and said, "Mr. Hollow, is your firm going to file an answer in this case?" And the other attorney had not answered the case. And I didn't catch it over the weekend. wasn't looking at it. So I said, well, if Your Honor will grant us a continuance, I'll file an answer. I'm not just basically a postponement. So the judge says, okay, we'll take a half-hour recess. So he took a half-hour recess. I took a legal pad and hand wrote the answer. Took it to the clerk, and it was filed, and the case went on and was tried.
Probably wouldn't get away with that now.
I don't think we would get away with that now.
Okay.
In fact, my adversary in that case now sits on the federal bench.
Now, at some point, well, actually, I think for a good portion of your practice, you still kind of had your hand in journalism.
Yes.
And in fact, you still were involved, I think, at UT in a capacity with journalism. Why don't you tell us about what you did there?
I was. About 1970 or 71, Willis Tucker, who had been one of my instructors in journalism when I was an undergraduate, called me and said they were fixing to offer a course in communications law, because at that time he was the director of the new college of journalism, and asked me if I'd like to have a shot at it. And I jumped at the chance, because it didn't pay a lot of money, but it paid some money. And remember, I was still working on filling those dividers in the corner at the side of the desk. So I taught Monday, Wednesday, and Friday from 7:50 to 8:40, communications law in the College of Communications. From that time until about 1982 or so, when I think things got so busy I couldn't do it justice, and I had to quit. So I was teaching, and also had an opportunity to do some work for the Knoxville News Sentinel. I was working with Frank and David Creekmore and Tommy Thompson and Jimmy Babcock, who was a title lawyer, and Jefferson County Judge Teddy Willocks. He'd been county judge of Jefferson County forever. And Frank Creekmore introduced me to the News Sentinel work, and that's how I got involved with the Knoxville News Sentinel. It was interesting. The News Sentinel about that time was very active, very aggressive in investigative reporting. They had a couple of investigative reporters. One was, of course, Willard Yarbrough, and the other was a man named, I can't think of his name, it'll come to me in a moment. But both of them were excellent investigative reporters. Willard Yarbrough started doing an investigative series on corruption in Cobb County. And it got close to home for some people. And there were death threats made. And at that time, the newspaper in Cobb County, the Newport Plain Talk, had just been purchased by a young entrepreneur and newspaperman, John Jones Sr., John M. Jones Sr., and because he was owned, and along with his wife, owned and was running the Greenville Sun newspaper. And so he had purchased the Newport Plain Talk, and the Newport Plain Talk began to republish the News Sentinel's articles about alleged Cobb County corruption. So John M. Jones began to receive death threats as well. In fact, it got so bad that he, according to his sons, he put a shotgun in the back seat of his car when he drove back and forth from Greenville to Newport to the newspaper. And an off-duty Greenville police officer watched his home at night. Well, they picked on the wrong person, because John M. Jones Jr., John M. Jones Sr., rather, during World War II was a member of an elite all-volunteer force known as Merrill's Marauders. In fact, he now is the sole surviving original member of Merrill's Marauders, and their job was to conduct surveillance and disrupt supply lines behind the Japanese lines in the China-Burma India theater. So he really was a man who didn't have a lot of concern about other people's threats, because he'd survived the war and the dysentery and everything else, and had actually been on the staff of Lord Louis Mountbatten at the request of Lord Mountbatten. Very outstanding person. He's still alive. He's now a centenarian, 100 years old. So he wasn't going to back down. And at one point, George Shepard, who was the circuit and criminal judge, and I don't know whether he had direct involvement or not, but the criminal court clerk refused to allow News Sentinel reporters to look at the reports from the grand jury, the true bills or no true bills. Well, those are clearly public record. But they wouldn't let the reporters have them. So Frank Creekmore and I were successful in getting the Supreme Court of Tennessee to issue a writ of mandamus ordering the production of those grand jury records. And I was given the task of serving it. So the service was to take place on a Saturday morning. So I got a couple of copies, one to be delivered to the Attorney General of that district and the other for the judge. And I headed for Newport. Well, the first stop was in Dandridge to deliver a copy, or a copy of the writ, to Dutch Swan, who at that time was the Attorney General. And of course, news travels fast. So by the time I got to Newport, everybody was expecting me. And I drove around into what I call the back of the courthouse, the entrance to the courthouse that faces the railroad tracks, not the one that's on the main highway. And I found a place to park, and I walked up the sidewalk to the back door, and on each side of the back door were two very, very large people. They were males, and they were big. And they didn't look like they were particularly friendly. And as I approached the steps, they said, "Are you the one that's here to arrest the judge?" And I assured them that I had no interest whatsoever in arresting the judge, but I did have some papers I wanted to deliver to him. So they let me go in. And I went up to the second floor and down to the end of the corridor, and there was a small office, probably not more than 8 by 10, and there was a metal desk, and seated behind the metal desk was Judge Shepard. He was a slight-built man, and he looked his age. And as I walked in, he looked up at me and said, "Well, I don't know why you had to come all the way down here. These books are ready for you to look at any time." And he picked up the docket book. And you know how big and thick and heavy those docket books are. And I was surprised that a person as slight built as he was could pick the book up as if it was just like it was a newspaper. And he picked it up and he pitched it across the desk, and it hit the top of that metal desk, and a little roll of dust came up around it, and he went ka-whomp. He said, "Now you can just look at it all you want to." And I said, "Well, I'm not here to look at it, but I'm here to make sure that the reporters who are on their way will get to look at it." And we talked a little bit, and we were certain that everything was going to work out for the examination of the records. But you talk about being one cautious driver, man, you've never seen a driver as careful as I was when I drove out of Cock County that day.
Well, that's a segue into your involvement in the Open Meetings and Open Records Act. Can you talk about that briefly?
Briefly, the Open Records Act was passed in 1957, and it was amended from time to time thereafter. In 1973 or 74, the Open Meetings or Sunshine Law was passed, as was the Journalistic Shield Law. Those acts were written by the Public Affairs, the Government Affairs Committee of the Tennessee Press Association, which I had the opportunity to serve then and still serve. And we got a challenge to the Sunshine Law almost immediately, and it came out of Shelby County. So I got the opportunity to argue that Sunshine Law case in the Tennessee Supreme Court in Jackson, along with Memphis Council. And that was the Supreme Court's first opportunity to uphold the constitutionality of the Sunshine Law. So I've worked with open records and the Sunshine Laws ever since.
And I think, as you said, you're still involved with the Tennessee Press Association.
Oh yes, yes, I've worked with them for over 40 years.
Now, of course, because of your involvement with the News Sentinel and Tennessee Press Association, your practice moved in some respects, not completely, but in some respects into the First Amendment area.
It did. In fact, in 1982, it was kind of funny. I had early in practice, a group of 5 university students had hired the civil rights lawyer William Kunstler, to file a lawsuit against the university over its speaker policy. And they'd retained as local counsel Bob Ritchie. Bob Ritchie at that time worked for the university as a clinic instructor. So he was conflicted out of the case, and he referred them to me. So I tried that case in front of Judge Taylor, and Judge Taylor ruled the University of Tennessee speaker policy was unconstitutionally void for vagueness. And that was in 1969, Smith versus University. And then of course, there was that situation with the mandamus of Judge Shepard. And then in 1982, with the impending collapse of the butcher banking empire, a group of butcher-related individuals filed a lawsuit in United States District Court seeking to block the FDIC's takeover of the butcher banks. Now, for some reason, nobody will ever know why, Judge Taylor, sua sponte, sealed the entire record. I mean, the entire record. Well, when Ralph Millett, who was the editor of the Sentinel, found out about it, he was incensed. And we decided, we were going to challenge it. And the question was, were we going to ask Judge Taylor to look at his ruling, or were we going to go someplace else? And our best judgment was that Judge Taylor was unlikely to change his mind, and it would take time. So we filed a petition for writ of mandamus in the Sixth Circuit Court of Appeals, naming Judge Taylor as the defendant. So I have the dubious pleasure of having sued a sitting federal judge.
How is the First Amendment law, just briefly, how has the First Amendment law changed from the time you got involved with it, I guess, in the mid-'70s and now?
During the early 1969 to mid-'70s period was the evolution of the constitutional privilege protection in defamation cases, or the New York Times actual malice standard. And I was there and privileged to be a part of the process as the rule developed, and more privileges, more and more protections were extended to expression under the constitutional privilege concept. And then, of course, beginning with the Rosenblum versus Metro Media, and then Gertz v. Welsh, they began to pull back from some of the extremes of the constitutional protections, but they're still very significant.
Where do you see it going in the future?
Uncertain. If we look at what our present Supreme Court has done with regard to questions that we feel are constitutionally based, it seems problematic. One of the most important of the Bill of Rights, most important part of it is the First Amendment, because if you take away the words "Congress shall make no act" or make no law, then I think it leaves 45 words. And out of those 45 words grow at least 5 or 6 specific protections. No establishment of religion, right of free practice of religion, freedom of press, freedom of expression, freedom of assembly, freedom to petition the government for redress of grievances. And all of those in those about 45 words. And that includes everything, the ands, the buts, and everything. And out of that has grown this huge body of constitutional law. Without the First Amendment, this nation would not be able to function. And because Thomas Jefferson and Madison, they envisioned that. Jefferson wrote that if you had an informed electorate and literate electorate and a free press, all was well. And that was the theory upon which they based the representative republic which we have in the United States.
Do you foresee the First Amendment privileges being eroded over time in the future?
Not immediately, but if we look at the steady expansion of federal power, there is a concern that the First Amendment protections could be eroded. For example, the recent issue with regard to same-sex marriage. At the present time, from the U.S. constitutional decisions and the Tennessee Supreme Court decisions, a newspaper is free to accept or reject whatever content they want, be it advertising or news or whatever. So theoretically, a newspaper could say, well, we'll run heterosexual marriage notices, but we won't run gay notices. And if the Supreme Court should say that their decision with regard to same-sex marriage created enough of a constitutional privilege that it overrode part of the First Amendment prerogatives that for 2 centuries in this country have been part of the newspaper's prerogative, I guess, or privilege, that could lead to the complete abrogation of the First Amendment.
Well, as we sit here today in 2015, you've been practicing law for 51 years, if I've done the math correctly.
Yes.
And you and I have been together for 15 of those 51 years.
Yes.
And you've been a mentor to me. What suggestions would you give, or what would be, if you could kind of sum up your, kind of hard to do, but your 51 years practicing law, what would be the one thing that you would want a young lawyer or a lawyer considering, or someone considering entering the profession, what would you want to tell them?
Look after your law practice. It was told to me, look after your law practice and it will look after you. And the law is a jealous mistress. It doesn't really work to try to have a side profession. If you want to practice law. Devote your time to your law office and to your clients. Remember, you serve the client. The client doesn't serve you. So as difficult as that may be from time to time, you have to remember to serve your client with as much diligence as you can possibly muster. But when you use that diligence, try to keep your grounding and your focus on your ethical responsibilities to your client, to yourself, and to the other members of the bar.
Thank you.